Welcome to the People's Law School, sponsored by the McCracken County Bar Association. This segment is on family law, and I'm Cynthia Sanderson, Family Court Judge of McCracken County, and I have with me Michael Walker. He's a practicing lawyer who specializes in the area of family law. I'll be moderating this program today, and Michael will be trying to answer some questions along the way. And the first question I have about family law that I think the viewers may be interested in is grandparents' rights, and whether here in Kentucky we have what we commonly refer to as grandparents' right in light of Supreme Court cases, or one case at least, and other cases that have been handed down.
Right. There is a statute in Kentucky law that allows grandparents to petition a court for visitation with their children. And while the statute says that it's in the child's best interest, just like any other statute, there are cases in Kentucky and outside of Kentucky that affect how that process actually works. And of course, Your Honor, correct me if I'm wrong on any part, because you and I deal with this so much. A few years ago, there was a case with the United States Supreme Court called Troxel versus Granville. And the big rule that came out of that was that you have to accord a lot of weight to the wishes of a parent when you have grandparents who are trying to get visitation with the child.
Let me interrupt you.
Sure.
Accord a lot of weight. What does that mean in the layman's terms?
If a parent says no, or a parent says yes, whatever the parent's wishes are, the court needs to put a lot of importance on that, put a lot of value on that, as opposed to what someone else says.
All right.
There have been cases out of Kentucky that have interpreted this statute in light of the Troxel decision, and I can't remember I think it was the Scott decision that basically said if a parent said no, that wasn't reason enough for the court to say no, the grandparents could not have visitation with their grandchildren. And that could be either parent. It could be their child, or it could be their son-in-law or daughter-in-law. And then recent cases by I think it was the Court of Appeals said you have to consider a series of factors when you're a grandparent, when you're looking at a grandparent who has petitioned the court to visit with the grandchildren. And those factors can include the parents, either one of the parents' wishes, and that those wishes still get a lot of weight. They still get a lot of importance. But you also have to look at what harm might come to the child, or what benefit could come to the child, what relationship the grandparents have had with the child up until that point. Trying to think of what other factors there are.
Well, let me give you a hypothetical. Let's say that a husband and wife are still with the same wife. This is a first go around for both of them. And they have two little children, and the husband's mother wants desperately to see these two little children. She's having serious grandmother fits, as a lot of grandmothers do, but for some reason the father, her son, has fallen out of grace with her, and she's fallen out of grace with the son. And the son says, I do not want Grandma seeing you all. But now up to this point, these children, who are, let's say, 4 and 6, have spent a lot of good quality time with their grandmother and even grandfather, who coincidentally are also in an intact relationship. And the father says no, and that's been going on for the last 3 months. And she comes to you for legal advice, wanting to make sure that she can eventually see her children on some regular basis, just like she had been before. What would you advise her?
The first thing I would tell her, and I tell all of my potential clients this, I never make a guarantee. I think some lawyers, maybe not purposefully or out of cockiness, maybe they're just wanting to do a good job for their potential client. I never say you're going to get to see your grandchild, but I say this is what the court would have to consider. Now, if I understand correctly in your hypothetical, these grandparents have had a relationship with the child before. And up until the past 3 months, they had a good relationship with the child and the son-in-law, but now son-in-law.
Actually, it's her son.
Or her son.
Mm-hmm.
There's
This is a hypothetical.
Exactly. Well, it's eerily similar to some cases I've got. Not before you, though. But I would explain to them the factors. I would want to find out more about what kind of relationship do they have with the grandchild. What kind of tension is there? What's the cause of it? Did the grandmother have regular visitation with the grandchild up until that point? And I can't remember, how old is the child in this hypothetical?
Well, in this one it's 4 and 6. And to answer your question, what happened, and I'll pretend to be the grandmother for a moment, what happened was the 6-year-old came over and she was wearing fingernail polish, and she had gotten some lips into the lipstick and thought she was really cute, and the grandmother's kind of fickle about these things, and called the mother up and told her not to put fingernail polish on the child's fingers anymore, because she wasn't quite ready for that. And it got the mother upset, which in turn got the husband upset, which in turn told mom to stay out of business, and one thing led to another, and apparently, and again, this is a hypothetical, I'm making it up as I go, but what about that?
I think something, and that's something that the case law also addresses. The courts don't want grandparents meddling in otherwise fit, and that means legally fit, two parents who can raise their child. They don't want a grandparent picking up the phone and trying to run the grandchild's life through the parents. And it just depends on all of the other factors, the relationship of the child. Is this fingernail polish incident the only incident? Are there other incidences that occur? A court could look at it either way. And sometimes it just comes down to what the judge sees in the evidence. This person could be a very controlling grandparent, or it could be just one little issue, and perhaps it's not as big an issue to them when they think about it in retrospect, because they're now not getting to see the grandchild.
Right. So essentially there appears to be a list of factors that the court has to consider before it would grant the grandparent visitation. Right. But the ultimate issue is what's in the best interest of the child.
Exactly. And the courts in Kentucky, the statute originally said best interest, and then when the Scott decision came down, it made it it was a more strict standard. You had to, if you had a fit parent who said no, that pretty much closed the case. Now it's called modified best interest, and the modification are all of these factors. But even then, the courts have to pay some attention and give some importance to what an otherwise fit parent wants to do. I think ideally, and it's like any other family law case, and you see this all the time, the emotions are raw. Everything that's going on between the parties' lives gets under a microscope. Anything they say after they've hired a lawyer gets scrutinized. Some might say lawyers in the process help, some might say they don't. It just depends on the lawyer. I think it's always good to try to encourage a client, and I think it's good for any party in a family law action to step back, particularly where there's kids involved, and say, what's really important here? And the courts are going to look at what's in the child's best interest. And I think then you say, okay, we have a dispute here on fingernail polish. Can we work around this? And sometimes you might need a mediator or going to a counselor or something.
Yeah. That's interesting as a practitioner that you would make that point, because as I'm listening and making this hypothetical, while in the back of my mind, the fingernail polish probably was just the beginning, the icing on the cake, or the straw that broke the camel's back, to say, to use a metaphor or a cliche. Lots of times it is a situation where when the parties can come together, if you can try to weave out all the emotions and get it set aside, and ultimately figure out that we're all there for the same common good, and that is for the children, and not for their own individual egos or personalities, then ultimately they may be able to get along without the lawyer or without the court hearing. But oftentimes it takes lawyers to try to allow them to know what their circumstances are and what they must do or not do in an effort to get past this.
Exactly. I once described family law cases. It involves parties who otherwise are really good people. They're probably your friends at church, or you would see them at a restaurant or a ball game, get along well with them. But once they go into court and it gets into the point of contested litigation, the emotions are so raw, and that's the tough. I think probably the toughest part in this area of practice to get through. Another joke I say: if there's cheating, meaning infidelity, or there's children involved, there's a higher likelihood of having raw emotion. On the other hand, you might have two people who are married and it's just not working out for them anymore, and they want to make as amicable a break as possible. Something I've read about, and I haven't seen a lot of it here, I've seen it in other cities in Kentucky, is the process of collaborative law, where basically, but the parties have their lawyers, but nobody goes in and files any motions in court or files a petition. They just try to sit down and say, hey, let's work all of these issues out. And really, and for you potential clients out there, from a cost perspective, it's a lot easier to try to sit down and work things out than it is to go before the judge. And I think it also goes into the issue I mentioned of stepping back and thinking about what's important. Let's say it's a case where there's not kids involved. You know, what's really important here? Does a party need to fight over this lamp? I had a case where we had a hearing over a computer. The parties had 4. Mm-hmm. Why have a fight like that? Of course, as an attorney, you're supposed to zealously represent your client, but
right. But what is important to people, and what should be important to people? Are we to make that decision for them?
I don't think we can. I mean, it's really up to them. As a lawyer, you advise them on the law, and you can give them moral advice if you want under the ethics rules. But ultimately, if they make a decision and it doesn't amount to committing a crime or suborning perjury, your obligation as a lawyer is to zealously advocate their position.
Right, and in society that we live in, where there's wealthy people and then there's not wealthy people, mm-hmm. and then there's very impoverished people living right here in our community.
That's right.
It's just a matter of how big the pie is or how small the pie is, but everybody wishes mm-hmm. to have a portion of the pie.
Exactly.
And to minimize or to not give due consideration to someone else's pie or their portion of the pie, right. like you've given the next person, right. is somewhat unfair, I think.
And I think you do have to, when you're sitting down with the client, if that one computer is important to them, you fight for it. And of course, they're going to have to pay you to do it. But if that's what they value, it's kind of like principles of economics. What's the value?
Well, I'm not one to encourage litigation, and I certainly wouldn't encourage litigation over items of personal property, right. which is disposable. And I try to bring that home to folks. Peace of mind to me is a whole lot more important right. than whether you have a computer that's going to be outdated in a year or so or less anyway, versus seeing your child, being with your child, right. having quality time with a grandchild perhaps. All of that right. has a hierarchy of needs that we need to give consideration to when we really go into court and start picking right. our battles.
Exactly, and there are the tougher cases too, and you've seen them with dependency, neglect, and abuse, where the child has been put in a situation that they have no control over. And
right. But well, when we talk about family law, that's not an area that most people come to think of readily. That's and right. When we talk about dependency, neglect, and abuse, that's exactly what it says. It's children are either dependent. There's mm-hmm. nobody who is available to take care of them.
That's right.
Maybe their parents are deceased, imprisoned, or have just left, which mm-hmm. would fall into the category of neglect, which is the second component, where the parents are not properly taking care of their children. And mm-hmm. I mean at basic levels: food, clothing, education. And I'm not talking about just failing to send your child to school one morning.
Right.
I'm talking about not registering the child for 6 months to school, perhaps. But mainly it goes toward food and shelter, and it usually affects the smaller children. And then there's child abuse, which there's kind of a crossover between neglect and abuse.
Mm-hmm.
Oftentimes when you have neglect, you have abuse and vice versa. And I have a whole week or a whole day each week dedicated to that, and lots of days each week. I have emergency hearings just for that purpose here in McCracken County, where children are neglected and abused, and that also falls in the family arena. Unfortunately, a lot of these children only have one parent, or they may not even be in the care of the parent. They may be in the care of another caretaker who may have custody or guardianship, and for whatever reason they're neglecting or they're abusing that child. And either the Cabinet for Health and Family Services, that's the governmental agency that comes in and seeks the protection of the child, they intervene and bring the petition before the court, and the whole action starts on an emergency basis, and everything goes and keeps going until the child is safe without stop. So those type of cases, are you familiar with those types of cases?
I'm familiar with those, and occasionally I get brought into them. And, they can be initiated by the cabinet, as you mentioned. They can be initiated by another parent. Sometimes they're initiated by another relative, and sometimes they're maybe a friend or a stranger. It can be a wide variety of people. And when that case is opened, if I'm not mistaken, here in McCracken County, the petition will come before you with an affidavit stating out the facts. It might say the child has lots of head lice, sleeps in a den of pit bulls, and has medication within reach, and you have to look.
It's a mild one. That one probably would get rejected.
But ultimately,
you
determine whether to issue an emergency custody order. Right. And at that point, the child is placed either with a relative or someone that the cabinet makes that decision. And then I believe the next part's what's called the 72-hour hearing.
Yes.
Tell
of course, everybody has to have notice of that first hearing.
Exactly.
Well, no. The signing of the petition is without notice.
Right.
That's called ex parte, without notice. And so I sign the petition if there's a legal basis for it, where you think that the child is in serious, the threat of serious injury, or has serious physical injury, or a sibling has one of those, or death, like if a child has been killed and you need to protect the other child from that, or the neglect is so severe that it poses a serious physical injury risk to the child. But once that's signed, it has to be done within 72 hours of the next hearing to determine whether the signing of that was appropriate. And of course, those folks would have notice and come before the court, and then if the continuation of that removal is granted, in other words, if the child still stays away from the parents, you set another hearing, appoint everyone a lawyer, including the child.
Right.
So you try to get to the bottom of these things. And unfortunately, more often than not, these cases are well-founded and not frivolous in nature, because you have to have some very significant grounds in order to get to first base on these things. I was being facetious when you listed those grievous events, but I say about head lice, it's no crime to have head lice. It's a crime to keep it.
Exactly.
You know,
Exactly.
kids have it, but when they perpetually keep it, that's when there's a question mark that needs to go off and a light bulb needs to come on. And
that's something where I went back to saying that you have people who are generally good people and they try their best, and there might be one incident, head lice might be one, the kid has head lice, that happens, but suddenly it's not a federal case, but somebody tries to make a state case out of it. And parents, like all people, are not perfect, and sometimes things like that happen. And so when I've had clients come in and that I've represented in cases like that, often the cabinet is involved. And what they'll do is they'll set out a parenting plan or a case plan that they work out, or that the cabinet makes suggestions. And I don't know if you can comment on this or not, because I don't want to put you in a position of giving legal advice. My general rule when I talk to potential clients, and there are exceptions, is that if the cabinet is making recommendations, you want to work with them. Of course, if you have a serious objection, you have a right to fight that out in court.
Sure. Of course, the cabinet is there to pursue what's the best interest of the child.
Right.
And there's no question that ideally the best interest of the child would be for the child to remain intact with its family, with its immediate family, or the caretaker that's taking care of the child at that time, if that's how it's been for a while. So they have that commonality to start out, that they want the parent to continue to take care of the child, if the child will be safe. But they also want to play it safe, play on the safe side, and make sure that there's no risk that's going to cause this child to be endangered. And that's where the case plan comes up. They say, we want you to do A, B, and C, and they will enumerate what they expect, and it may go down to X, Y, and Z, but we'll say 1, 2, and 3.
Right.
We want you to make sure there's an adequate supply of food in the cupboards and refrigerator. We want to make sure you bathe your children daily, or just some very straightforward, run-of-the-mill items, and that's why because it's spelled out so precisely, sometimes it gets to be a good laundry list. But certainly, I think it's best for the family to work with the cabinet to keep the family together. Whenever the cabinet has intervened and filed a petition to remove the children, the cabinet still must work with that family to reunite the family with the child. I think it's a good idea to work with the cabinet when you have your child removed and you're wanting to reunite, because the law requires that the cabinet use reasonable efforts to reunify this family. And if you don't want to work with the cabinet, then they don't have to use reasonable efforts, and the court will even not require them to do so if the parent chooses not to work with them. Because what are reasonable efforts? Well, I'm doing the best I can, but if you don't want to give back, there's no reasonableness here.
Exactly. We were talking beforehand on the topics to cover today. And I'll tell you a question that I had come up, and I have this come up a lot. And since we've got a family court judge on the program, you're probably the perfect person to comment about it. When I have potential clients come in for custody, they'll call about a custody case. And let's say it's a case where the child's 13 or 14 or 15. And they always say, well, I heard or someone told me, and that someone's usually not a lawyer, that when this child is 13, when a child's 13 or 14, they can tell the judge who they want to stay with, and that's enough. What's the reality on that statement?
Well, that's interesting, because I bet a week does not pass by that someone doesn't actually come into court and say that to me. Well, I know my child can come in and tell you, and we can just switch custody. No, that's not how it works. In fact, even if you file the motion to change custody or to get custody, and you say the child wants to live with me, if I'm the person filing the motion, that still is not sufficient. And you get into court and you present the evidence, and the child is interviewed by the judge and says, I want to go live with the parent. That's still not in and of itself sufficient. At any age, doesn't matter how old, the statute in Kentucky provides that it is only a factor to consider out of a long laundry list of factors. Obviously, the older the child gets, the more important that factor becomes
Right.
and it starts becoming a high importance factor as opposed to one that has very little significance. If a child, and when I say it may have little significance, it depends whether or not there's been bribes, whether there's been promises. A lot of that can come into play, which totally discounts the significance,
Exactly.
if not counteracts the significance of the child's wishes. So I think that that is important for people to understand, that just because a child wants to live at a certain place at the age of 14 or 15 or 13 doesn't mean he's going to get to change his ways. In fact, I have been known to go against a fairly old child at times when when the writing on the wall does not seem to indicate it's in the child's best interest to do that.
Of course, there are a lot of viewers out here that may be thinking about going through a divorce or something. When sometimes they start talking about it, sometimes they don't. They just hire a lawyer and they go and get one. What would you say to someone who's thinking about pursuing a divorce, whether there's kids involved or not? What kind of action should a party take if they're
Now,
considering?
do you want my lawyer answer or do you want my judge answer?
I think either one's good, because I'm learning a lot here from talking with you about this.
Well, of course, if I were a lawyer in private practice and they really thought about going through a divorce, I would try to explain them divorce planning and so forth, but that's not what I think you're asking me. I mean, there are certain things you can do to plan for a divorce.
Right.
But from a perspective, even as a practitioner, back when I was practicing law, I would ask people if they've really given this a lot of thought and how serious they are, because the grass is not always greener on the other side.
Right.
It just simply is not. And I think if there's one thing that we all, I think our time's getting close by here, but if there's one thing that we all can take home with us from this program, is that life is not always a bowl of cherries, and I know that's real cliche, but it's not always a bowl of cherries, and you really need to look twice before you cross over, and look maybe 3 or 4 times before you cross that line into thinking that you're in the wrong relationship. It has been a pleasure, Michael Walker, to have you today, and this is Cynthia Sanderson, Family Court Judge. Thank you, viewing audience, for being with us today.
Thank you, Judge.